Mr President, just a couple of brief comments on this bill. I too believe it's appropriate for us to extend the retirement age for our judges. I think, as has been pointed out in the second reading speech and by others, we are all living longer and are able to contribute in all kinds of ways as we do so. We also have particular challenges in our court systems, and having availability there to address those is important. We can certainly also, I guess, on the one hand assume that we can actually acknowledge there's no reason to assume that with increasing age comes diminished capacity. That's not the case in many ways and in many different professions. In fact, I think what we can assume and acknowledge is that with increasing age, we have some very particular benefits that come from the benefit of experience and that wealth of knowledge that can be drawn on, and potentially the judiciary is a very particular example of this, where the benefits of that experience and knowledge really come to the fore. I acknowledge that the argument has been made by some who participated in the consultation for this, and also in other forums where this is discussed in other jurisdictions, that perhaps there should be no retirement age put on judges, and I think that's an interesting question. I think it then would present us with issues around and questions to ask about who then would decide when the right time to retire is. It can be hard for individuals to have appropriate objectivity to make that decision for themselves, and if we weren't to rely on people to make that decision for themselves, we would then be faced with having to devise some mechanism as to who would make that decision and what mechanism that decision would be made within, which is problematic. So I understand why we've landed on a retirement age being identified, and in this case extended. On the other hand, as I was reading some material related to this bill, I was also acutely aware that we have a lack of diversity amongst our senior judges here in Tasmania. They are predominantly senior white males, and that retirement provides an opportunity for renewal and for improving diversity. If we extend the retirement age and apply it to sitting judges, what we then potentially get is an extension of that lack of diversity, which I think should be contemplated, and we should be thinking about how we can make improvements to that. I know the government made some comments around improvements to diversity and efforts towards that end. I think we can think more carefully about that too and have that in mind as we go forward. The one point I did want to raise and perhaps question in relation to this bill came up as I was looking into the sorts of discussions that have been held in the past in other jurisdictions and at the Commonwealth level and other states when changes have been made to judicial retirement ages. And what I noted was that there is typically a generally expressed view in almost every instance where the question arises, a generally expressed view that any change being brought in shouldn't apply to sitting judges, that it is prospective, so it looks ahead and applies to future judges. So that I then do have a question about that and what consideration was given in this instance with this change we're proposing to make here about the appropriateness of applying the change to sitting judges. And I'll just share a couple of the pieces that prompted my question about this. In the first instance, I came upon in reading that when we first introduced retirement ages at the Commonwealth level for judges, the then Federal Attorney General Bob Ellicott, in his second reading speech on that legislation, referred to that legislation being, and I quote, an important safeguard to ensure, and I quote, there can be no suggestion that the amendment is directed against any existing judges or that those judges will be prejudiced in any way by the amendment. So they were mindful of applying this only to prospective judges rather than sitting judges. And the second place I encountered that same sentiment was when I looked at the issue when they were contemplating retirement age in the Northern Territory, and in a submission put forward there by the Criminal Lawyers Association of the Northern Territory, I came across their points raised about this issue of bias. And they say in that submission, which is from December 2018, changes to judicial tenure risks the appearance of interference with judicial independence if they apply to sitting judges. And then further, a couple of paragraphs down, to avoid this perception of bias, any increase in the retirement age should only apply to future appointments and not to any current sitting judge. So, picked up on that same theme. And then the third place I came across this was when I looked at a report, or some Hansard, actually, a hearing from a Senate committee, the Legal and Constitutional Affairs References Committee, a hearing that was held in 11th of June 2009, where they were looking at a similar thing. And this is just a very brief comment, but I think it speaks to this general view. And it was made by Professor George Williams. In questioning, he was discussing the changes to retirement age for judges, and I quote one comment he's made there is, "Of course, any changes to the retirement age should not affect any sitting judges. It should only operate prospectively." So this is what I came across again and again. And the fourth one, I'll just provide one further encounter with that same view. It was in an academic paper published by Alicia Blackham, published in 2016. She is a senior lecturer in Melbourne Law School at the University of Melbourne and an affiliated lecturer for the Faculty of Law at the University of Cambridge. And in her paper, which is Judges and Retirement Ages, the similar sentiment is expressed, and I'll quote here from page 743, I believe. The changes to Section 72, which was that Commonwealth legislation, and any subsequent changes to retirement ages operated prospectively to safeguard judicial independence. Judicial independence requires the absence of certain connections between the judiciary and other arms of government to secure impartiality in the conduct of the judicial role. Former Chief Justice of Tasmania, Sir Guy Green, defines judicial independence as the capacity of courts to perform their constitutional functions free from actual or apparent interference and, to the extent possible, actual or apparent dependence on the executive. According to Lane, guaranteed judicial tenure is essential for securing judicial independence. Thus, changes to judicial tenure under Section 72, which was that Commonwealth one, risk impairing the appearance and reality of judicial independence if they applied to sitting judges. To manage this risk, the changes to Section 72 only affected new judicial appointments. I think I'll leave that quote at that point. It goes on into more detail. So that was just to illustrate that I encountered this concept from a range of sources as I did a quick bit of reading around the issue. And then it was brought into mind, because I know here at a local level what we have seen is that the Chief Justice has actually been advocating for this change. And in fact, in the Mercury newspaper, in an article on the 3rd of February 2021, Chief Justice Alan Blow is quoted there as saying that he said it seemed, and I quote, inevitable that recruitment and retention of talented judges would become more and more difficult if we didn't increase the age, suggesting the state government raise the retirement age to 75 in a bid to alleviate recruitment problems, as well as to enable current judges to make better provisions for their retirement, which I think is concerning, to have a Chief Justice advocating for an extended tenure to make better provision for his retirement. But I think it also just highlights for us whether we've contemplated sufficiently and dealt with that matter of the appropriateness of a prospective change, looking ahead to future appointments, compared to the application of this change to existing justices. It's important that the court can operate without that connection between judicial and executive, either for better or for worse. That there's no benefit or disbenefit that has occurred as a result of a decision, the executive side of things, that then makes the judiciary inclined or disinclined to maintain their impartiality in their decisions. So my question, I guess, for the government is, could you give me some detailed answer as to how that has been contemplated and assessed, and then the decision made that this would not be prospective instead of applying to existing judges.